watching this video. And this is a very brief J6 video presentation on the topic of NRM. The reason being, for those of you who watched it before, I did a talk on NRM and modern slavery back this spring. And since, I suppose, two recent cases, the law has changed. So I'm providing this video as a way of an update, but also as a way, as a bit of marketing to relaunch then again our J6, our Junior 6 lectures, which are starting again for this academic year as such. So on the 23rd of September, we'll have Zoe Chapman and Tim Kiley presenting. And then on the 25th of November, we'll have Amy Rees along with Francesca, I think it is. And what we're really hoping to do with those is, COVID permitting, having them in person. But again, as before, we will hopefully have them online with slides and the recorded presentation so that people can follow at their own time. I know people have commitments, but ideally we're hoping to welcome as many people as possible to Chambers, and as always, there'll be refreshments available afterwards. And I've just been informed by my email, 25th is Faye Rolfe, not Francesca. Sorry, Francesca and Faye, for watching this. So I hope this will just be a brief 10-15 minute talk. The slides will be available as well. They'll be uploaded so you can follow with me. What I'm going to do now is hopefully share my screen, and in that way we can all see the slides together, and hopefully my face will come up on the top right. I'll keep it like this. So this is effectively trying to look at where we are as predominantly defence advocates when dealing with NRM trials. And I'll whistle through a lot of the material that was covered before. I feel that a lot of people are still a little bit confused about, well, what should we be doing, or where are we exactly in relation to the admissibility of the NRM decision. And this is, in a nutshell, trying to clarify that by saying, well, actually, the NRM decision now won't go to the jury, but perhaps us as criminal practitioners have a way of trying to instruct experts as we did before. So in many ways, a bit of a disappointing result, but that is where we are, as clarified by the Court of Appeal. I've highlighted here the NRM process. We're all probably sick to death of it by now. I do, again, reiterate that the CPS have an obligation to consider whether to prosecute in light of any NRM positive decision. I still think this stands that the general trend is we don't really take a view, put your client in the witness box and it's up to the jury, unless there was overwhelming paper documentary evidence, which maybe we should be looking at trying to obtain to put before the CPS at that stage. And I've highlighted there the importance of letter of representations. I'll come back to this at the very end, but I just set out the section 45. Ultimately, what we're interested in is whether the person was a victim of modern slavery. You'll see the tests differ between adults and children. Set out the CPS guidance. Before, I discussed a lot about R&DS, which seemed to say, great for us defense practitioners, it's all admissible, the prosecution can try and test it, but the jury will get to hear about it. And there was a case of R&GS as well. Then I think the way it had been left was this case by His Honour Judge Farrell in Cambridge. It was being circulated by the Crown Prosecution Service. Effectively, he called evidence, heard about the NRM heard about the NRM SCA's ability and expertise, and ultimately said no, not admissible. That then was where we left off, and I think I ended the lecture by saying, watch this space. However, I'm not confident that it will be admissible, and I think it was a bit of a negative note. But then suddenly this case of DPP and M arrived, and this is not the law as it stands, because it's subsequently been changed by the Brecani case, which we'll come on to. But I thought this was an interesting point, and perhaps the peak for defence practitioners. Set out the facts there, but in that case it was the youth court for bladed article and drugs. He relies on the section 45 defence, and actually the conclusive grounds decision went in by way of agreed fact. Now the district judge let that in, and then the divisional court on appeal decided that actually the SCA's decision, the Senior Competent Authority's decision, is relevant and is important evidence. They then outlined the status of this decision, and in a nutshell, there are 2 points there. They're saying the SCA decision maker has expertise, it's admissible, but the jury can look to see what weight they want to put on that decision depending on the expertise of that decision maker. They then go on to say that ultimately that's the jury's arena. Prosecution can test, can adduce evidence, can say that they haven't met the defendant, can undermine it, and the jury are entitled to look at the SCA's decision and come to a different one. And they end there by saying a conclusive grounds decision will not be determinative in the criminal context any more than it is in a tribunal proceeding. So in this tribunal it was allowed, and they then went on to speculate and said, well, actually, in the criminal jury arena, we also think it's applicable. So everyone up and down the land was thinking, finally, great, our hard work is done, I think, because the moment the jury here, there's been an NRM decision, we can back that up with psychological experts, which I'll talk about later, and then the prosecution have a way of, I suppose, disproving the NRM finding. So that was that. That lasted for a few months, and I think after that decision, it was the case in practical terms that courts were actually allowing the NRM decision to be admitted as an agreed fact, because that was the law as it stands. So if you're lucky enough to have 1 or 2 of those cases during that time period, hopefully the NRM decision was recognised and the jury found accordingly. But then came this case last month, which was the case of Brecani. This came around about the summer, and apologies for slight delay in this. And it was relating to a case in March 2020. And it went to the Court of Appeal. And I've set out the reference there. And ultimately, in this case, the appellant was convicted of conspiracy to supply cocaine Class A, and he was 17 at the time. And now he relied, again, on Section 45 of the Modern Slavery Act as his defence. Now, what occurred then at trial was that there was a bit of toing and froing. They hadn't reached a conclusive grounds decision. As we're all aware, these cases take a considerable amount of time. And they refused to sever the defendant from the other defendants who weren't necessarily running the Section 45 defence. Now, the CPS then, quite rightly, reviewed the case, and what they found was contradicting the defendant's account was a lot of phone evidence. So showing the individual not necessarily having been trafficked, not necessarily showing him to be selling drugs under compulsion, but an individual living, I suppose, what they said was a very normal teenage life, going out with friends. And if you read the case, there's details discussion about him ordering escorts on the phone, evidence for him and his mates as such. And they said, listen, we're pressing on. And they pushed on. And while the trial was underway, the conclusive grounds decision, that's what I mean by CGD, was made. And that was positive. That the defendant, the 17-year-old, was a victim of modern slavery. They found that there had been forced criminality in Albania and in the UK, and ultimately that he was compelled through others older than him to sell drugs. Now the CPS, unlike in the case which we were discussing before, DPP and M, said, we're not making admissions on that. They would have been, prior to the DPP and M case, and we're probably going on the old case law that we discussed before, they said, we're not making admissions, and the court ruled before trial, or during the trial, that they were not admitting the conclusive grounds decision as expert evidence. And therefore the jury didn't hear anything about it. The defendant was subsequently convicted, and there were 3 grounds of appeal in total. One was to do with the lack of severing, but the 2 that we're interested in is, number 1, whether that CGD, the conclusive grounds decision, was admissible as expert evidence, back as held in the case of DPP and M, which we looked at before. And 2, whether this independent forensic social worker / criminologist evidence should have been admitted. And that's a slightly more nuanced point, which I'll deal with at the end. But ultimately, it was decided at trial that Mr. Barlow couldn't give evidence essentially on behalf of the defendant. So it went to Court of Appeal on ground 1 regarding the Senior Competent Authority's decision, the conclusive grounds decision. They said no, and quite firmly so. And unusually so, they stated, we disagree with the judgment of the Divisional Court in DPP and M. Ultimately, they said these competent authority caseworkers are not experts. They cannot give opinion evidence in trial. And it's not enough to say, just because someone has that role, they are, as in caseworkers, they are in fact experts. They then go on to say they are far removed from these air accident investigation branch experts. They use that as an example, discussed in civil proceedings. And more so, they say, well, listen, if you look at actually our Criminal Procedural Rule 19, there's no obligations effectively attaching to these individuals. So number 1, you don't have the expertise. And number 2, actually, you don't even satisfy the initial necessary requirements and rules governing experts. So there we are with that. Incredibly unfortunate for defendants. And I'll come back to potential implications at the end. But just as an aside, and I think it's relevant for us when we're looking to try and instruct experts to circumvent the fact that the NRM decision is no longer admissible, they looked at Mr. Barlow, and you can read the case, but ultimately what was put before the trial judge was just that Mr. Barlow has done a PhD in modern slavery. What looks not to be put forward to the court were the fact that he had extensive knowledge in training, in acting as an expert for different bodies in Europe and in the UK, and had been called to give his expertise in numerous instances, not akin to a criminal trial, but definitely as some sort of expert role. That didn't go before the trial judge, and that was commented upon in the decision. So they found, just to go back to this, that in view of the material provided to the court, that's just the PhD, they did not find effectively that Mr. Barlow possessed, by virtue of study or experience, sufficient knowledge of modern slavery as opposed to other specialist subjects. And ultimately, that means that his opinion on the subject would not be of any value to the jury. Now, also, they looked at the process by which Mr. Barlow had found his conclusions, or how he had come and reached his decision. And there were two effective assessments by Mr. Barlow, one on the papers and one with a brief interview with the defendants. Now, he came to the conclusion that effectively he was a victim of modern slavery, and in many ways parroted, my understanding is, the version of the NRM conclusive grounds decision. But importantly, he took what the defendant said as effectively given. So the interview itself is essentially criticised for not being analytical enough and for not being scrutinising enough of the defendant and the defendant's account. And what it appears that Mr. Barlow had not considered, and maybe that it wasn't provided to him by defence or in fact by prosecution, but what he hadn't considered was contradictory evidence in the form of the phone evidence, which I highlighted to you earlier in relation to the facts of the case. That's point. Yes, that's point 2 on this slide, that ultimately there were extensive messages showing, as the court found, the defendant effectively living his best life, not at all under duress. He was maintaining contact with his family and friends. I think there was comments on the jovialness, and then I mentioned before about him buying escorts for him and his colleagues. There was also evidence of frequent travel, unaccompanied, between the UK and Albania. So they said, and the court found, that ultimately those messages didn't really seem to support the defendant's account, and more importantly, the expert hasn't had sight of them. And the expert hasn't used effectively the CPS's case to critically examine what the defendant was saying. So they found, for those reasons, we are unpersuaded that Mr. Barlow had demonstrated sufficient knowledge of modern slavery in the context. That's the first point that I discussed, or that he had considered the range of facts necessary for reaching an informed opinion. So what I think we can learn from that, and I'll skip some of these slides, is ultimately the importance of expert evidence. So that expert will need to, one, be a proper expert, be able to document and evidence their expert opinion through qualifications from previous experience. My initial reaction was, wow, that's incredibly, these people are going to be very hard to find. I have heard some through charity organisations and some who sit on boards of the National Referral Mechanism itself. My only hope is that through these trials and through the need of these experts that there will be an increased visibility of who we as criminal defence practitioners can approach and when we need to. What I also think is there's a tendency for the experts to focus on, is that person a victim of modern slavery? Whilst I also think that experts can give evidence on perhaps the more complicated hurdle to jump in the Section 45 defence. And that is, it's the final box here, is adults. A reasonable person in the same situation, blah, 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 would have no realistic alternative to doing this act. And I think that's a lot of times, perhaps the majority of times, where the defence case falls down, where, yes, we can convince the jury that the defendant is a victim of modern slavery, but actually, if you look at the circumstances in which the defendant was in, did he have no realistic alternative doing the act? Did he have to carry those drugs? Did he have to be in possession of particular weapons? Could he not have gone to the police? Could he not have left London? Could he not have gone away and taken his and gone to his social worker? Or could he not have reported to his care worker? The defence, I think, was initially overestimated by defence, by us, saying, great, we've got this NRM, we're a slave, we're going to win all these trials. But actually, if you look at the law, it's very, very, very akin to duress. Like, unless that person is ultimately being held captive, manipulated to a real strong degree, and has vulnerable characteristics that potentially just go beyond age, I think we need to focus on how there is a real difficulty in achieving limb 4. Now, importantly, that's where an under 18 probably has an easier time, because slightly different test, and a reasonable person in the same situation as having the person's relevant characteristics would do that act. So slightly lower bar there, and I think I would definitely be more inclined to run an NRM Section 45 trial with respect to an adult, with respect to a child, than with respect to an adult, as outlined before. So then I think we need to be looking at our experts, not just is he a slave, but how much so is that individual mentally scarred or traumatized from seeking assistance, mistrustful of people in authorities, reluctant to look at legitimate forms of escape, of getting out of the modern slavery. And I presented these on the slide here, really in relation to vulnerability, susceptibility, and compellability. And those need to become documented by the expert, because ultimately they then could be imputed into the defendant's relevant characteristics at the trial and at the route to verdict stage. And there will necessarily be a discussion with the judge about what legally will count as a relevant characteristic depending on the diagnosis. It's sometimes easy, I think, to work backwards, being like, what are the jury going to get told and how do we get them there? So I've put again the route to verdict up. You'll see there are 3 ultimate questions. And I suppose then in this whistle-stop tour of NRM, I think it's a frustrating conclusion. I can see why. And I have written an article about it, analysing DPP and M. It was an Archbold with Real Comey Jones QC. I can see why the court said this isn't expert evidence. And I think that's a harsh reality we have to come to terms with. And I think a lot of us were pushing it and willing it to be expert evidence because we ultimately didn't have an alternative of trying to show to the jury that our defendant was a victim of modern slavery, because it seemed like such a complex thing, given that there was this mechanism in place to deal with it. And I think perhaps sadly as well, it really puts the onus on Defence Counsel to go out there, instruct a psychiatrist, instruct an NRM expert, whether it be someone from Salvation Army or someone involved in the NRM mechanism at a higher level, rather than the SCA caseworkers who have been criticised in the case of Brecani. And then not only instruct them, but ensure that they have all the material, can document their expertise, and can document their reasoned thought process, which demonstrates the fact that they haven't just taken the defendant at his word, but have scrutinised his account, having looked at the prosecution's case and what they're relying on to effectively say he's not a slave. So thank you for bearing with me in that. It feels a little bit mismatched to do this talk without having a live audience and not to be doing it with others as part of the J6 lecture. But I think we were conscious in J6 that as we had left it with NRM, it looked like that, great, like the NRM decision was admissible, and since then we've had two important decisions in the cases of DPP and M and Brecani. Go out there, read any queries, email us at J6. You can email me directly. It's on the website. And I'm happy, obviously, if I've made any mistakes, to amend slides, correct any ambiguities. But again, a final plug, and I will get it right this time, for our two lectures coming up in the 23rd of September. Again, all being well, we hope to do it potentially at a venue in Chambers, depending on the refurbishment. And the 25th of November, 23rd, Zoe and Tim, 25th, Amy and Faye. Well, thank you very much for listening. I hope everyone is keeping well.